Amendment that provides that you are entitled to citizenship by being born on American soil. We're going to talk a little more about that in a moment. There's been an attempt to suspend the enforcement of laws that are designed to ensure that there's racial diversity in government, that the people who serve us reflect the racial diversity of the population they serve. There's been some efforts to freeze all of the civil rights enforcement matters that are now pending before the Department of Justice. There's been an attempt to suspend funds appropriated by Congress specifically for the purpose of defending the right to vote. And we're even worried that there's the possible detention of American citizens as part of efforts to enforce the nation's immigration laws. We're hearing numbers out of executive officials that they intend to round up millions of alleged non-citizens in the country who have committed crimes. Well, there are not that many people in the country who are non-citizens that have also committed violent crimes. So who are these other people that fit in the definition of millions that can expect to be detained? Each and every one of these pieces plays a role in our right to vote. I wanted to start just with a little bit of history of our country and some of the gifts that we've been given. Even though our Constitution and some of our founding documents were, of course, in extreme error, especially as they treated African Americans that had been brought forcefully to these shores. Those documents, despite their flaws, have a number of incredible gifts to us that preserve our liberty, and those gifts can still be presented today in court. One of the things that came up in the constitutional debate was how is it that we prevent government from overriding the desires of citizens? How is it that we can design a government of the people, by the people, that shall not perish from the earth, as Abraham Lincoln would later say? And nobody really knows. It's been lost to history whether Madison or Hamilton wrote Federalist 51. But one of the things they warned us about was breaking into ambition, and that ambition of various parties and ambition of various citizens might be a threat to liberty. And so that's why they designed a system that had different checks and balances, different branches of government that would work against one another. And as the Federalist 51 says, ambition must be made to counteract ambition. But one of the things that the founders did by separating powers into the judicial, legislative, and executive branch is they expected those branches to work against each other. In other words, protect their branch power rather than communicate or coordinate across branches. But the advent of political parties quickly changed that. In fact, in George Washington's farewell address, he gave this statement, giving deep concern that political parties might ultimately override the project that they had created in this Constitution, and that instead the political parties would coordinate across branches. The Republican Party, for example, would control Congress and have a Republican president and a Republican majority, as some allege, in the U.S. Supreme Court at the moment. The fear is that political actors working across the branches will no longer protect the party of the powers of the individual branch, but instead will work in party interest instead of American interest. And certainly we've seen that happen with both political parties as they gained advantage in multiple branches of government. But it's the courthouse where oftentimes the judiciary is fiercely defensive of its rights and powers. And because the members of the judiciary are appointed without regard to political party, they are appointed by political presidents, but they serve for life. And because of this, they have proven to be remarkably independent. Now, of course, all of us have stories who try cases in federal court of a judge who's long past their ability to serve in terms of age. And that sometimes happens with this lifetime appointment. But that lifetime appointment is what has preserved our judiciary as the last sort of safe harbor of resort, as I mentioned. So I wanted to show you this. This is a photograph, actually, of me examining Wendy Davis, a former state senator in Texas who ran for governor there and became noteworthy for a filibuster she committed to try to stop a bill that would restrict abortion rights in Texas. And this trial was over the photo voter ID law that Texas passed in 2011. We ultimately beat back this law, but in this room are Republicans and Democrats, and on that bench is a special 3-judge federal court that included 2 judges appointed by Republicans and 1 appointed by a Democrat, and they voted unanimously to strike down Texas's discriminatory photo voter ID law. So the judiciary is a place where there are people committed to the rule of law, regardless of the political issues of the moment. So I wanted to talk to you a little bit about what are some of the ways that government tries to deny the right to vote. And we typically break that into 2 different categories: vote denial and vote dilution. And I'm going to talk about some of those older methods and some of the newer methods that we're seeing. So vote denial devices are exactly that, where the government prevents you from voting. Whatever it is your choices, they won't be recorded and they won't be tabulated. So an example of that are what we call grandfather clauses, which I'll talk about in a moment. Literacy tests, which I'm going to show you an example of, and poll taxes, which I'll show you an example of as well. But all white primary elections are another example of this. States all throughout the country, including some counties here in California, but the entire state of Texas and many other places, until the U.S. Supreme Court struck it down in the 1960s, and in particular in a case called Smith v. Allwright out of Texas in 1943, the states would decide who could vote on the basis of their race. And white persons could only participate in the general or primary election, and other people of other ethnic or racial backgrounds were denied. So that was an old vote denial device that for the most part has been beaten back by law. There are voter registration. Voter registration in particular was created as a vote denial device. Once the southern states had to start registering black voters during Reconstruction and then later during the Jim Crow period, they erected these voter registration systems to set up another barrier, another place where they could deny people who were African American the ability to vote. Poll watching of an aggressive nature, having police officers or people dressed aggressively, can be a vote denial device. And of course, closing polling locations, keeping fewer polling locations so there's longer lines, all these things can result in the denial of the right to vote. But one of the first things I just mentioned was a grandfather clause. Frankly, I had taken that out of my slides, and I've been giving a presentation similar to this for 2 decades now. And I took grandfather clauses out of the presentation because it was something that was so remote in time. But here we see it coming back again with the present administration. A grandfather clause is named that because Southern states during Jim Crow would pass laws that say you could only register to vote in that state if your grandfather was a citizen of the United States and a citizen of that state. It was a way to ensure that formerly enslaved persons and their children would be unable to register because they'd be unable to prove that their grandfather, who was an enslaved person, was a citizen of the state. Thankfully, those have been struck down and sort of worked out over time. But a little bit of what you're seeing the administration attempt to do now by trying to suspend the 14th Amendment is a lot like a grandfather clause. It's trying to limit who it is a citizen of the United States. And of course, that's important to them because of once you're a citizen, you have the right to vote. Now, folks might agree or disagree with the policy of whether you're born in the United States entitles you to registration or citizenship. And, I suppose reasonable minds can disagree on that. But what reasonable minds can't disagree is that that has already been decided, and it's been placed in the U.S. Constitution at Article 14. So there are things in the Constitution I wish were different, and it's incumbent upon me to try to convince the political system to amend the Constitution. Until then, I have to live with it. For example, the Electoral College. And likewise, the 14th Amendment has amended the Constitution, and it provides in the first sentence, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. Indeed, the entire Civil War was fought over this very issue of who it would define citizens of the United States. And Amendment 14 is one of what we call the Reconstruction Amendments. Some people call them the second founding documents, whereas the Constitution and the Bill of Rights were our first founding. The 13th, 14th, and 15th Amendment, which were secured by the blood of hundreds of thousands in the Civil War, are also part of our formation. This question of whether or not you're a citizen when you are born in the United States is also not a new one to the Supreme Court, and it's not one that has been in any way controversial. One of the leading cases on it is United States versus Wong Kim. It's an 1898 case, Unless you think the U.S. Supreme Court was some progressive body in 1898, let me remind you, in 1896 is when the U.S. Supreme Court issued the Plessy versus Ferguson decision that allowed separate but equal and essentially allowed Jim Crow to set in the South for the next 60 years. Those same justices, despite their views on race that I find abhorrent, nevertheless didn't find it a difficult question when presented with a case where a Chinese national living with his parents, who were also Chinese nationals, living in California, who were renting a home. This child was born to those Chinese parents in that home. And his parents ultimately left, went back to China. Later, the child decides to go back to China to see his parents, and the United States will not allow him re-entry. He sues, goes to the U.S. Supreme Court. He says, I was born in the United States. The 14th Amendment says that I'm entitled to be a citizen of the United States, and the Supreme Court, 7-2, agreed. There have been a number of decisions since then, including one in the 1980s, where the U.S. Supreme Court specifically found that persons born to undocumented immigrants or unauthorized immigrants, aliens as the Supreme Court terms them, are also citizens of the United States because of the 14th Amendment. So, what happened when the administration tried to suspend this article? It went to court, a district court enjoined it, which means it no longer has effect. And my suspicion is it won't even go to the U.S. Supreme Court, that lower courts will strike it down and suspend this this executive order, and that'll be the end of the story. But I'm confident if it gets to the U.S. Supreme Court, it will be 7-2 or 9-0 to strike it down. Here's another example of a vote denial device, and these are actual poll tax receipts from as recent as 1965. These are out of Orange County, Texas, which is over on the Louisiana side down towards Houston. And these poll taxes were paid by a client of mine. Indeed, I've represented many people over the years in Florida and Louisiana and Texas who paid a poll tax and still vote today. In fact, there are tens of millions of voters that remain voting today who were forced at times to pay a poll tax, pass a literacy test, and overcome several of these other hurdles. And so here's an example of a literacy test that I bring up now because we were seeing more and more people advocate that these should be brought back. The argument that we heard about the literacy test back when they were ubiquitous across the country from the 1900s to about 1964, and they remained in use until 1970. This one's from 1972 from Louisiana. But the idea was, well, if you don't know enough about, to read, then you can't read the paper. And so why would you have the knowledge you need to vote for citizens of the country? That was the good government argument. And it's similar to these photo voter ID arguments. Well, if you can't go get one of these IDs and jump through all those steps, are you really competent enough to decide, who you should vote for? But really the purpose of the literacy test was to put you in front of a government officer. So the government officer could identify you by race or some other like identification, and then could decide to fail you based on that. And that's why racial minorities failed these at tremendously high rates. And if you notice here in the questions, they are ambiguous. Some of them are impossible to answer, but others, essentially allow the person who's grading the test to come up with what the answer is based upon identifying you and looking at you. So, some of these might not seem so hard. Draw a line around the number or letter of this sentence. Draw a line under the last word in this line. Cross out the longest word in this line. All right, some of those, are maybe we can figure those out. But then here's the rest of the test. Divide a vertical line into two equal parts by bisecting it with a curved horizontal line that is only straight at its spot bisection of the vertical, and other examples here. And so you get a sense that the purpose of this is not to determine whether you have the ability to receive political news and therefore make your own voting choices. The purpose of this is to give a government official discretion as to whether or not to allow you to vote. And then oftentimes that discretion was exercised in a racially discriminatory manner. So those are some of the older types of racially discriminatory voting practices, but they are by no means the only type. And since the advent of some of the laws I'm going to share with you today, crafty people have been coming up with new ways to restrict the right to vote. One of those, for example, is a restrictive photo voter identification. I believe that in an ideal system, the government would require photo voter identification. And often the argument we receive from other people is that most other countries do this. And that is true, but it is also true that those countries provide the photo ID. The federal government issues a photo voter ID to every person without charge and without barrier at the time of their birth initially, and then later when they turn whatever their political age is in that country. Instead, the photo voter ID laws that are being advocated here are at a state by state level. They involve a necessity to collect a number of documents that always cost quite a bit of money. In many cases, the documents aren't available. And I'll give you an example. I represented a man who's passed now. His name is Floyd Carrier. He fought in the Navy in World War II, excuse me, in the Korean War. But he was born actually on the corner of Orange County and three other counties in Texas. They come together like the Four Corners states do. And none of the clerks, he was born at home, like a lot of African Americans were in that time period when they were not allowed to get medical assistance by the local hospital. And none of the county clerks would register his birth because he was born at a house that was on the corner of each of these four communities. And so he lived his entire life without a birth certificate. He was unable to obtain one. So when Texas passed its restrictive photo voter ID law, he tried to go vote using his U.S. Navy veteran ID, which had his photograph on it. And that wasn't one of the IDs that Texas had authorized to be used, only one of the IDs that they authorized, that they had selected based upon the data, by collecting data to figure out which photo voter IDs were most held by white people. And so the government military ID was, and his or veterans ID was not one of those that was selected. He was denied the right to vote until 3 years of litigation. We finally secured it back for him. And he was able to vote a few more times before he passed away. That isn't an isolated story. There are thousands, tens of thousands of those people in every state that, through no fault of their own, cannot obtain all the documents the government wants from them, and therefore denied the right to vote. The federal government could solve this problem, as it does in Mexico and Canada and other places, and issue an ID. But of course, that's never the advocacy for people who want photo voter ID, because the idea behind the photo voter ID law, just like the literacy test, is to give discretion and erect another barrier so certain people won't vote. Proof of citizenship requirement sounds reasonable enough, but again, proof of citizenship, how many on this call would find it easy if pulled over on the way to Ralph's to pick up grocery and an officer asks you to prove your citizenship? Will you have a passport? Will you have your birth certificate? Will you be able to go get originals of them? Will there be any errors on them? Are they going to match your name exactly, or has your name changed? Or did the government clerk record something wrong on that form? Your liberty is in jeopardy of any one of those mistakes or omissions. That's what proof of citizenship requirements do, and it's why you see it in fascist regimes, like we did during World War II, is constant effort to make people prove their citizenship as a way to pick and choose the preferred and non-preferred classes. Limiting absentee or early voting, racial targeting or law enforcement against racial minorities. We're seeing a great deal of that in Florida and Texas at the moment. Ballots rejected based on a signature mismatch, people who can vote by mail or vote absentee often have their signatures compared, and the employees who do the signature comparison are usually white or Anglo, as we'd say in Texas. And as a result, what you see is Hispanic or Asian surnames, surnames that you can identify the race or ethnicity of the voter, are rejected at much higher rates than are, white Anglo European names. A lack of curing provisions. In other words, we saw this during the recent elections. You forget to put the date on it, or you forget to put your last four digits of your social security number or some such thing, and they deny your ballot. This is what we're seeing in the North Carolina Supreme Court race at the moment. There's 60-some thousand voters who failed to put a particular number on their vote by mail application. They've been confirmed to be eligible voters. They're absolutely entitled to vote, but the Republican candidate who'd lost by a few hundred votes is arguing all 60,000 ballots should be thrown out for, essentially failing to dot an I or cross a T. Poll watcher, some people call it election integrity moves, where people stand out in front of the polling location and intimidates. We see people bringing firearms now in states that allow the open carry of firearms. In Texas, often Black and minority neighborhoods where their polling locations are. We'll have militiamen standing out front with machine guns and other weapons, just trying to encourage people to drive away rather than come in and vote. Artificially creating long lines and limiting drop-off locations. Texas, you might recall in 2020, Florida did the same. It made it to where if you were able to vote by mail, you couldn't mail it back in. You had to bring it to a drop-off location. And that location, there would only be one of them in the entire county. So for example, Harris County, which is roughly 5 million people where Houston is, you had to drive downtown and drop off your box. It'd be the equivalent of living in Thousand Oaks and being required to drop off your ballot in downtown Los Angeles. That kind of burden. And for those of us who sit in traffic, we understand what kind of burden that is. So those are modern vote denial devices. But here's another example. This is now the governor of Texas, Greg Abbott, but he was attorney general of Texas until 2006, I believe. And until then, he would go around doing voter slideshows about things we need to look for to prevent all these illegal votes from being cast. And these are actual slides from a slideshow the current governor of Texas would show people throughout the state. Here's one. You need to be worried about early voting in person, and we need to make sure everybody understand all laws apply. And look at the photograph that the state elected to use in this presentation, and see if that doesn't bother you a bit. But if that was a little too subtle, you want to give the governor the benefit of the doubt, maybe that's just the photograph they could find of somebody in line, then this is the next slide. We want to examine all these documents for fraud. There'll be obvious signs of tampering. There'll be some handwriting on the forms, maybe a different form signature. And one thing we can look out for is unique stamps, like this African-American woman holding her baby and a stamp dealing with the sickle cell anemia. So these things are modern devices that continue to this day. So we spent all this time talking about vote denial, and now I want to talk about vote dilution. Vote dilution is where you're allowed to vote. The government comes in and lets you vote, but through the setup of the system, your vote doesn't mean anything or it doesn't mean much. Most often this comes up in redistricting, how the individual districting maps are drawn. For example, your member of Congress and how their district is drawn. But there are other methods to engage in vote dilution, such as reducing the number of districts. We see this often. If there are 9 districts on the city council and it's starting to look like a district or 2 might elect somebody from the other faction, the government will say, no, we're only going to have 7 districts, so they can more easily dilute the voters that we're about to have a chance to elect. And then oftentimes they'll create other kinds of district systems where you'll have 4 at large and say 5 single member districts. Again, making the single member districts larger and larger so that the political majority, and most often the racial majority, can outvote. So I'm going to give you some, kind of a visual example of packing and cracking. These are the 2 primary techniques that map drawers use when they draw political maps. This could be for your school board, your county commission, and of course for Congress. And so I want to kind of introduce to you this concept of what we call wasted votes. So imagine you had 50 precincts and it's roughly 40% teal and 60% blue. Put that as, that could be Republicans or Democrats. That could be blacks and whites, or Hispanics and whites. But imagine that we're looking at a community where there are 50 precincts and this is the rough division. And let's say that they have 5 districts. And so we sit down and we draw a map that looks like what we've drawn here, where we have 5 districts. So 3 of them, the teal will win, and 2 of them, blue will win. Now, before I've pulled this apart and done any more explaining about what techniques are involved here, I've already made an anti-democratic process, right? I've taken the 5 districts and I've ensured that 40% of the population can now control a majority of the districts, even though they're not a majority of the community. This exists all over America, including places here in California, but in particular in states that are aggressive about redistricting, like Texas and Florida and North Carolina and Illinois on the Democratic side. So in addition to being undemocratic in the larger sense of sort of who wins office. It's also undemocratic for the individual voters, and that's who we term our wasted votes. So let me see if I can, pull that apart for you. So first, to talk about cracking and packing, we pulled this apart. The crack districts are 1, 2, and 3. See how we've taken some of these blue voters and we put them with just enough teal voters to wipe them out so that we can ensure in those 3 districts, teal is going to win. And then meanwhile, with the other blue voters, because remember, blue's the majority in this community. We've got all these other blue voters we got to do something with, so we packed them into 2 districts. There's only 1 green precinct or teal precinct each in these 2 districts. Because we have to let those people elect somebody, so we're trying to get as many of them as we can in as few districts as we can, because we're trying to keep teal in charge. So we calculate from this a wasted votes. So surplus votes are the votes cast for the winning party in excess of 50%. So we look at a district and how many voters did we need for it to perform for teal or blue, and how many does it have in excess of that? And then lost votes are the votes cast for the losing party. How many people voted for the losing party in a district? And we can do some mathematics and we can come up with what's called wasted votes. So again, going back to our example, same redistricting plan, we can tally up over here surplus or lost votes. These are votes that aren't needed to get the outcome in that district. So if you take those people out, that district is still going to vote the way it was designed and drawn to be voted. And you can see how we can tally that up for each side, and we can come up with a mathematical measurement of how much a redistricting plan wastes votes. Now, you might think, okay, well, people do this on a partisan basis. Nobody in the modern era does this like on a racial basis, right? Surely there aren't people in America that are sitting down going, what we need to do is figure out how to get as many Hispanic voters in as few districts as possible. But here's an exhibit from a trial I was involved in Texas in 2011. And down here at the bottom, you'll see one of the lawyers that was helping with the redistricting effort is talking to the main map drawer that the legislature hired to draw a map. And he talks about this thing he calls the nudge factor. He said these metrics would be useful in identifying a nudge factor by which one can analyze which census blocks, when added to a particular district, help pull the district's total Hispanic population and citizen voting age population up to majority status, but leave the Spanish surname registered voter and turnout to the lowest. In other words, go find voters who are Hispanic but don't vote, and let's identify them in the map and let's put them into the map. So now we can go tell the government we drew a Hispanic district. See, we haven't violated the Voting Rights Act, but we'll know because we're using our nudge factor that what we really did was we created a district that looks Hispanic and that will perform for Hispanic people, but actually won't, because we picked Hispanic people who won't actually turn out to vote. The court ultimately turned this down as an intentional racial gerrymander in violation of the 15th Amendment of the U.S. Constitution, and most of the damage these people did was struck down by the court, but not all of it. And this the only reason this got struck down is because they were silly enough to have put it in an email that we were ultimately able to discover. But if people are willing to lie about it and aren't willing to put it into emails and text messages that get discovered, lots of this stuff gets past the judicial referee. And so I want to give you an example of how using cracking and packing is affecting our current politics. This is a measurement of wasted votes in state legislature maps in various states. And what you're going to see is that Texas, for example, is like a +15 racial gerrymander for Republicans. California, although it's blue, is like a +4. Florida is like a +20. North Carolina is a +20. All of these dark red states have aggressively drawn their map to ensure that Republicans get elected. But states like California, even though it has a blue tint, is just barely a Democratic gerrymander. In fact, if I redrew using the skills, and I was willing to do this, which I'm not, but if I redrew the California congressional map, there could be 2 Republican congresspeople elected from California. That would mean Democrats are in control of the House today. California's decision to be fair and have a redistricting commission is the reason, along with other states, that Republicans are in control of the House. You may like that result, you may not. But Some states are not engaging in nonpartisan redistricting. They are engaging in aggressive partisan redistricting. And there are blue states and red states that do that, but there are many more red states than there are blue. Now, it didn't used to always be this way. It used to be that the country was more evenly balanced. There was still racial gerrymandering and political gerrymandering going on in the red and blue states, but from 1972 to 1980, when Democrats were in charge in the South, they were aggressive then about redistricting in favor of Democrats. But on balance, the country was more balanced politically, at least in Congress, because there was roughly an equal number of states and seats being gerrymandered. Now, that didn't do you any good if you were a Republican outside of San Antonio in Texas who should have had the right to vote for a Republican congressional candidate, but were drawn into an urban district where your voice was silenced. It didn't help you individually, but at least nationally, it wasn't messing with Congress. The current system places a great imbalance in Congress as to what the voters actually would prefer. So now we talk about what our tools are, what it is that I use when I go into court to try to strike down some of these vote dilution and vote denial methods. And of course, we have the U.S. Constitution. Individual states have constitutional provisions. Their Supreme Courts enforce them at different levels. For example, Texas has a free and fair elections clause. Its state Supreme Court does almost nothing to enforce. California has a free and fair elections clause in its state constitution, and its Supreme Court is aggressive at enforcing it. So state constitutions can read almost identically in one state to another, and they have completely different outcomes on what's allowed in that state based upon what the state Supreme Court rules. But there's nevertheless protections there, and we seek to enforce them even in the states where the state Supreme Court doesn't necessarily favor the provisions. But what has been the crown achievement, the U.S. Supreme Court said is one of the most important acts ever passed by Congress is the Voting Rights Act of 1965. After Bloody Sunday and the Edmund Pettus Bridge march of John Lewis and others, the public went into an uproar and rightfully demanded that something be done to prevent Southern states from using violence to keep African Americans from registering to vote. Congress responded finally, century late, with the Voting Rights Act of 1965, which is still the main protection any one of us has against the government trying to take our ability to cast a ballot. We're going to talk about that a little bit more in a minute. Then there's also the National Voter Registration Act. People call this the Motor Voter Law. It was passed under the Bill Clinton administration that entitles you to register to vote at government offices and otherwise gives you a right to sue the government under certain circumstances when they won't register you. There's another act that was passed in the George W. Bush administration after the 2000 election called the Help America Vote Act that has important voter protections, but unfortunately, it did not provide a right for a citizen to go into court and enforce the Help America Vote Act. So it does a little bit of good for us, but it's not like the Voting Rights Act or the National Voter Registration Act, where each of us who is an American citizen is entitled to go into court and demand that a government officer be ordered to comply with our right to vote. And then, as I mentioned, there are state voting rights acts, and then, of course, state laws can protect the right to vote. They can also suppress the right to vote. So I want to just spend a minute and talk about what the U.S. Constitution provides by way of voting protections. And I would just point out, and it's shocking to a lot of people, the U.S. Constitution does not, in its original form as ratified in 1787, did not provide for a right to vote. Nobody has the right to vote under the U.S. Constitution. In fact, it deems states as being in charge of the federal government. States would appoint senators, states would appoint electors who would then vote on president. There was election for members of Congress, but only insofar as your state permitted. And so in the original 1787 Constitution, there is no right to vote. The right to vote doesn't enter the Constitution until we fight the Civil War, which was principally about liberty and the right to vote. And in response to that, Abraham Lincoln proposed and was able to pass and ratify the 13th, 14th, and 15th Amendment. The first place the right to vote appears in the U.S. Constitution is in the 15th Amendment, which I'll put on the screen here. It prohibits the denial or abridgment of the right to vote on the basis of race, color, or previous condition of servitude. The next amendment, which your organization was critical in ensuring both the passage and ratification of is the 19th Amendment, which is the right of citizens to vote shall not be denied or abridged on the basis of sex. Then the next place that the right to vote appears in the Constitution is the 24th Amendment, which is that you can't be required to pay a poll tax or other tax. But in other words, you can't have the right to vote denied or abridged on the basis of your wealth. Everybody, all of us are equal in terms of our ability to vote, no matter how much money we can put our hands on at all. And then the final place the U.S. Constitution talks about the right to vote is the 26th Amendment, and which says the right of citizens to vote on cannot be denied or abridged on the basis of their age. This was passed is the most recent amendment that has been passed on voting. It was passed in 1972, and a number of people who had fought in Vietnam returned home and were 19 or 20 and were unable to vote, even though they could risk their life and limb for their country. And so the country rallied together and amended the Constitution to ensure the right to vote for all people on the basis of age, as long as you're over the age of 18. So that is all our Constitution says about the right to vote. And I think that's why for most of our nation's history, the right to vote has been diminished. It was limited to the few. And so I think that what we're seeing now is an effort to kind of return to that place. So Congress passed the 1965 Voting Rights Act, which had this provision in it: no voter qualification or prerequisite to voting shall be imposed or implied to any state in a manner that results in the denial or abridgment of the right to vote. But that language itself isn't a lot different than the 15th Amendment. So the Supreme Court came along and said, look, this is the same as the 15th Amendment. You have to prove the government is intentionally discriminating. And Congress amended the act in 1982, and President Reagan signed it, and added what we call the effects provision, which I won't go through in detail. There's a number of factors that we have to prove. But this provision that is on your screen right now is what is standing between the government taking your right to vote. It is your last best hope in the courthouse to secure your right to vote if the government has decided, to take it from you. And so, this is the kind of case that we bring under the Section 2 of the Voting Rights Act. And these are the kinds of things that we have been able to stop. I'm going to sort of skip since we're out of time here. These are the factors that we have to prove in court. And as you can see, what I would hope you take away from this is it's complicated and it's not easy, but we win, more than we lose. The Supreme Court, recently bolstered the act, much of our surprises. But the U.S. Supreme Court just 2 years ago bolstered the act and said it remains constitutional and it allows the protection of the right to vote on the basis of race. And it did so in a case in Alabama. This is the congressional map of Alabama. On the left is what the state tried to draw. On the right is what we call a heat map, showing the concentration of Black and white population in Alabama. So the redder the area, the more higher amount of Black citizens live there. The whiter the area, the higher amount of white citizens live there. And if you'll see what the map did was it took the Black population on the eastern edge of the state and split it in half, and then also peeled off important parts of the large Black population in the western part of the state and buried them in other districts. Packing right here, cracking right here, just like we talked about. And that resulted in only one district that would elect a Black candidate of choice, when instead the state is 40-some% Black and should be able to elect at least 2 members of Congress. So these laws are doing, important work today. And the judiciary, although not God, or not made up of gods, certainly has a lot of right to secure our liberty. There's plenty of people of immense talent all over the country that are there to continue to fight for the right to vote. So I think I'll stop it there, and I'll stop sharing my screen. And I think now is the time to take up some questions if I haven't timed these things, if I time this right. So
yes, we actually have a couple of questions already in the chat, so I will let Sue Strickland squeeze in her questions at this point, and just keep them brief, which she has in the chat. Sue? You probably have to unmute. Well, let me read the first of her questions. um, do you believe that Trump will be successful in his attempt to deny birthright citizenship?
No. The first court to get it has already enjoined it, and I don't think he'll get a court to rule for him anywhere. But if he does, they'll get reversed.
And another one is, do you foresee term limits or for federal judges or the Supreme Court judges ever being enacted?
I don't see term limits ever being enacted, and I think they're a terrible idea. In fact, it, when we survive the current political crisis, as I view it, it will be in part because of lifetime tenure for judges. Now, that doesn't mean that there aren't people on the bench that long ago should have retired, and there aren't people who stay beyond their mental capacity. Those things happen. But any other system I've seen proposed allows a political person like the president or someone else to essentially keep their hand around the throat of the judges they appoint to the bench. So it is the appointment of judges for lifetime that I think is one of the reasons our constitutional system endures.
And I would also say that if anybody wants to raise their hand, I will try and call on them. In the meantime, I will also ask a question. What do you think would really be the best thing, the most effective way of guaranteeing the right to vote for people? That what could be changed now?
Well, we need to amend our constitution. We need to adopt a constitutional amendment, and I think it will happen. I think it will happen in my lifetime. But we need to say that there's an explicit right to vote, that it's individual, that you're able to enforce it in court, and that it may not be denied or abridged. And we need to lay out a specific standard, that courts have to follow to when they're addressing government regulations to determine whether or not the right to vote's been suppressed. So I think that's the number one thing we can do. But one of the things that we learned from our own nation's founding, but also many others, is that it's a community of citizens, and so it takes each and every one of us to protect each and every one of us right to vote. And so just talking about it like we're doing here today in this discussion, and spreading the word that you're right to vote, spreading the word that these things are in danger with some of the examples I've given you today. Hopefully, you're not just taking my word for it. I tried to give you actual evidence of things that are happening contemporaneous right now to harm your right to vote, and then just helping everybody remember, you may be okay with it now because you're getting the political benefit of it, but it will turn. At some point in time, every one of our rights to vote becomes at risk, and so we all have to stand together.
Okay. Penny, would you like to um, go? I see your hand raised. Would you please like to ask your question?
Sure, thank you. I was having trouble. I couldn't write my question in Q&A. So if I'm thinking about the league and looking forward to the time in the future where we're going to have redistricting and there will be somehow, a group brought together to draw those lines. So what could be the league's role in educating people about, well, to use your example, the cracking and packing, and what other kinds of things should the league be teaching to our citizens when they're to educate the entire population and also those people who are going to be taking part in the drawing the lines?
Well, I think lifting up the stories of people who are impacted by these regulations. I don't know enough about what your chapter of the league in particular does to give much constructive criticism, but I will say that, like, oftentimes people see the right to vote and the struggle for the right to vote as somebody else's problem, or they see it as an old problem that we solved. And the more that the citizens begin to understand that there are places, there are not many of them, but they will grow, I can assure you. There are places in the United States where Republicans' votes are being suppressed. There are places where white citizens are being suppressed by a historical minority that has now become the political majority in that community. And now I don't want to say, it's 98% the other way around. But the reason I point that out is whoever gets in charge, human history has shown, will seek to suppress. In fact, if you go back and read Federalist 51, towards the end of it, they talk about how human history is replete with citizens, with country after country where the political majority, racial majority, punch down on the racial minority. And at any given moment in the United States, we're all in danger of that. In fact, I think some of the people who are sort of motivated by this anti-immigration rhetoric instinctively believe that the reason they're worried about that is because they view that they might become the racial minority or the political minority, and they know what could be done back to them. And the solution to that is we should just make sure it's illegal for everybody to do it to everybody, the right to vote. So I think lifting up these individual stories and the individual people that are the victims of this conduct, everywhere we see it without regard to partisanship or race or ethnicity, is the most important thing we can do.
Oh, thank you. Linnea, would you like to go now?
So I read a report from the Brennan Center that following 2020 elections, at least 30 states enacted 79 restrictive laws. Do you think that those had an actual impact on the outcome of the 2024 elections?
Well, I don't think it changed who won the presidential race. It's extremely difficult to manipulate the election laws at this stage where you can change the outcome of a presidential race. I mean, you'd have had to have three other states. Three states would have to go a different direction for Donald Trump to have not been elected. And so you would need massive vote suppression in three states to pull that off. And it's the same reason he couldn't prove it in 2020 when he claimed to be a victim of it. It's just at that scale in an election that large where we got several 100 million voters, what the vote suppression laws are having an effect on individual people and probably tens of thousands of individual people, but it's not changing the outcome of the election. But one of the things that I get that kind of question all the time. And one of the things I like to bring up about it is, but it doesn't matter. If you're Floyd Carrier and you fought for your country in the Korean War and through no fault of your own can't receive a birth certificate and now can't vote, it doesn't matter whether Floyd Carrier's vote would have changed the outcome of election. What matters is that Floyd Carrier, a United States citizen, was suppressed. His right to vote wasn't secured, even if it had just been another tally in the winner or losers column. This is a right. It's an individual right. It's not a collective right. And I think a lot of times we fall in the trap of going, well, if it doesn't make any difference in the election, what difference does it matter that there were 3.5-hour long lines to wait in Georgia? Well, the answer is because hundreds of people went home. Many others didn't bother to go vote because they saw that line. And those are American voices that were silenced, whatever the outcome. Now, having said that about the presidential election, there are no doubt in my mind local, city council, county, municipal elections whose outcome is different because of suppressive laws. So there's no question it affects election outcomes, but it didn't affect Bush v. Gore in 2000. It didn't affect Trump in 2020, and it didn't affect Trump and Harris in 2024 in the outcome, but certainly voices were silenced.
Okay, now we actually have Sue. Would you like to go ahead now, Sue? And unmute.
Thank you. Wow. Okay. Doesn't the Constitution give states the right to set the rules for state elections? But federal elections are the purview of the Constitution. Am I correct in that?
Mostly here. So Article 1, Section 8 of the U.S. Constitution has what's called the Elections Clause in it. And the Elections Clause says that the individual states shall set the time, quote, time, place, and manner of elections, unless Congress shall otherwise direct. So it's like what we call a preemption power. The states have the initial right to set the election rules, but Congress can override them. Now, that has historically been interpreted as Congress can override them with respect to federal elections. But as part of the Civil War and the Reconstruction Amendments, the 13th and 14th and 15th Amendment, the 14th Amendment was adopted that said, and included in it, says that states can't deny the equal protection of the laws. And so for the first time, the first 10 amendments to the Constitution were applied to the state, which would include the right to associate and the right of speech in the First Amendment. And so it has been the argument on the voting rights side that states are obliged, that the right to vote is fundamental and that it's part of the right of expression in the First Amendment. I mean, what is the point if you can go talk, but you otherwise don't get to talk on a ballot? And so if that is true, then the First Amendment applies to states by virtue of the 14th Amendment. And so states are limited in their ability to suppress their voters. That's not where the law is at the moment. The U.S. Supreme Court basically says Congress can override any laws that pertain to the federal government. But the Supreme Court has never said that states are free to do what they want to suppress the right to vote. And indeed, there's what's called the Anderson verdict test that's currently been adopted. And the Anderson verdict test says that the U.S. Supreme Court adopted test says that we're going to measure the amount of burden on the voter, and we're going to compare it to the state's justification for the burden. And if the justification doesn't match the burden, we're going to strike down the state's election law, whether it applies to state or federal elections. So there is some limitation. I know it was a long, complicated answer, and it probably would bore my law students to have gone through it. But essentially, the takeaway is Congress is in charge of federal elections. And they've got and the federal government has some authority over state elections, but the Supreme Court hasn't fleshed out exactly where the boundary line is.
Thank you so much for clarifying that. And just as a side note, I have pink sneakers thanks to Wendy Davis.
Okay, right. I represented Wendy Davis in that trial, and her testimony ended up being the highlight of that was before she testified in that trial before she did the filibuster. So.
That was so powerful. Thank you.
Let me see. Maddie, would you like to ask a question, or should I read it? You can go ahead if you like. I will just. Okay, Maddie.
Okay. Yeah, I was just wondering, a lot of states deny voting to convicted felons, even if they're out of jail. And that feels to me like voter suppression. And I was wondering what your opinion is on that.
Sure. Well, the 15th Amendment. So one of the problems is that in the 15th Amendment, when it was ratified, there was a compromise in the Senate. And they added a language that a state could abridge the right to vote on the basis of, a criminal offense. And so unfortunately, until that amendment is changed, states are going to have some ability to prevent people who have been convicted of felonies from voting. Now, we've tried, and I've tried in a number of cases. We've been trying to get the U.S. Supreme Court to take up the question of shouldn't your rights be restored once you've completed your terms of sentence? Okay, fine. The Constitution says states can take away your right to vote as a part of your penalty for violating a felony, but can't you get it back? Aren't you entitled as a citizen once you've met your terms of incarceration, et cetera, to get it back? And I litigated a case in Florida. We ultimately lost, and we've been unsuccessful getting the Supreme Court to take it up, which is in its way its own victory, because at least they haven't taken it up and ruled the other way. So a number of circuits, which are the intermediate appellate courts right below the Supreme Court, have ruled that once you've completed your term of sentence, you're entitled to your right to vote back. Other circuits have decided that differently. In Florida, we got a ruling. In Florida, they have public initiatives like California does. So you can put things on the ballot, and you can amend the Constitution or pass laws by a vote. So they amended their Constitution by a vote of 60% of Floridians that said that you got your right to vote after your term of incarceration was over. So the legislature passed a law first saying we're not going to make that law. That got struck down. So then they came back and said, all right, that's fine, it's law, but term of incarceration means paying all your fines, fees, restitution, and costs of confinement. Well, if you have to pay your cost of confinement for a 5-year term, most people will never do that in their lifetime. It's so much money, it adds up. The government, so effectively prevented people from ever being able to retain the right to vote. Anyway, the courts ultimately allowed that, so that's the law now. Interestingly, if President Trump's criminal conviction is ultimately affirmed on appeal, as a resident of Florida, he'll be facing headlong into that statute. So the cost of prosecution is also has to be repaid as under the Florida provision. So,
Wow.
Linnea.
Yes, have state voting rights acts been at all effective in turning back voter suppression?
Oh, they have been life-changing. I'll give you an example. Well, first I'll tell you about California because it deserves the most credit. It passed the first California Voting Rights Act. And as a result of it, hundreds of cities, counties, school districts, water boards have gone to single member districts and now have districts that are drawn that with minimal packing and cracking. It was instrumental in electing hundreds, thousands of Hispanic office holders because they were now able to get run from single member districts and get elected rather than run at large in a community that was 70 or 80% white. So it's been incredibly effective. The California Act needs to be updated. There was several things left out of it that need to go in it. So it's not perfect, but it's great. But I will tell you a more recent example that we at UCLA Voting Rights Project played a hand in. Washington, the state of Washington passed a Voting Rights Act and in fact amended it with some language that we wrote for the legislature. And as a result, the Yakima Valley, which is in the eastern part of the state, the other side of the Rockies from Seattle, and that's where the U.S. nuclear arsenal mines a lot of its nuclear material, but it's also a lot of apple orchards and wineries and beautiful country. The Columbia River runs through it. And those communities have been 30–40% Hispanic going back to World War II. The U.S. government actually encouraged Mexican migration to the Yakima Valley to help mine plutonium and uranium for the nuclear project, the Manhattan Project. But those people had no ability to elect a candidate of choice to city, county government. Upon the passage of the Washington Voting Rights Act, several counties now have gone to single member districts, school boards, public utility districts are now electing Hispanic candidates of choice to their boards, and those folks are finally getting a voice. I mean, these are third, fourth generation Americans finally getting a voice in their local government. So yeah, state voting rights acts, even in, quote unquote blue states that you might assume in the current moment are doing reasonably good on voting, passing a voting rights act in those states makes a huge difference.
Minnesota recently passed one, which
That's
is
right.
addressing racism in urban areas.
New York's got one now. Virginia passed one. New Mexico's about to. Connecticut has one. So it's growing.
I would just be curious. I mean, the United States has a pretty low percentage of people who actually vote. And, do you think requiring people to vote would make sense? Or how else would you try and encourage wider participation?
Well, my view is that requiring people to vote is unconstitutional for the same reason that suppressing their vote is unconstitutional. Under the First Amendment, you have a right to speak, but that includes the right not to speak. So I don't think, without amending the Constitution in any way, that you could have mandatory voting, and I don't even think it would be advisable. But there are people who shouldn't vote and choose not to, and they shouldn't have that choice made for them. But they also shouldn't be forced to vote when they're, not in a position to do it. That said, there's no question we have abysmal turnout. It hovers around 50% for presidential elections. 50% of registered voters turn out. It's an even lower number of eligible voters. But I think a number of the barriers that we have are part of that. I think also it's the lack of community crises that we have seen another time, which isn't to say horrible things don't happen. And obviously 9/11 comes to mind in my lifetime, but we haven't had the type of drama or human calamity that, the Great Depression or World War, for example, even the Vietnam War, as difficult as it was for millions. wasn't felt on a widespread basis like the Great Depression or World War was or Civil War was. So I think sometimes it takes those kind of events for people to re-engage. They don't see one party different from the other. And so I think that, lowering barriers is the best we can do. And I think if we did that, we could get voting up to 60, 65%. But after another crisis, it would jump again into the 90s.
And I think maybe we have time for one more question, and then should let Chad Dunn get on with his day.
I don't see any hands raised. You know what? I will ask a question on behalf of a member who is not with us this afternoon. One of our voting specialists in our group, she really has concerns about when people are locked up, even pre-trial or just because they can't raise bail, that they should be allowed to vote. And if you aren't convicted of a felony, only a misdemeanor should be able to vote. And I'm not really sure where the law stands right on now on that, but if you could let us know about that.
Sure. It's a real problem. I could be corrected. I don't think it's a real problem in California. They actually go and have, ballot drop boxes in county jail. And of course, in California, everybody can vote remotely without regard to excuse. So I'm sure there's some isolated reports here and there, but by and large, the state as a whole facilitates the voting of people who are incarcerated that are otherwise eligible. It's night and day though, in states like Florida and Texas. You can forget about it. First, you can't vote in Texas. You can't vote by mail without an excuse, and being incarcerated is not one of the statutory excuses. So unless they open a polling location in your jail facility, you don't have an ability to vote. You can't get a ballot because you can't honestly swear that you meet the requirements to vote by mail. Florida does have no excuse vote by mail, but it doesn't provide for drop-off locations. So it depends on your ability to get the ballot, and a lot of times there's delay through security screening for your ballot to show up, and then you vote it, try to mail it back out. It goes back through security screening. A lot of times the ballot doesn't get to the election officer on time, and so it's a real problem there. So that is a state-by-state issue, and she's 100% right to be focused on it. There are places where, if you just have the bad luck of, those parking tickets catching up with you, and you get put in jail 2 weeks before the election in Texas, and you don't have the ability to bail yourself out, you also lost your right to vote because you're not going to get out in time to vote in person, which is otherwise going to be required.
Well, I do. This is Jean Thompson, of course, I'm talking about, and I know she has visited jails in order to encourage, just the people who are pre-trial, whatever, without any thing to make an attempt to vote. So I do appreciate that, and we thank you.
One thing I'll just say about that real quick is that the right to vote by mail is very interesting. We wouldn't have the 13th and 14th and 15th Amendment if President Lincoln hadn't decided, and the history on it is fairly clear, that there was a real concern on behalf of Lincoln and the Republicans that they were going to lose the next presidential election. I mean, the Civil War is on, and which would have been, essentially handing over the government reins to the South. And so they, and the people he worked with, and what many of us would call a cynical move today, rushed out a vote by mail policy to where mail ballots were sent out to servicemen on the front lines of the Civil War, Union officers and infantrymen, and they were encouraged to vote and sent it back. And there are reports that they were encouraged to vote Lincoln, and maybe they thought their commanding officer required it. Maybe there was some intention there. I don't know. I mean, lots of that's been lost to history, but there isn't any question that that Lincoln and the Republican Party created this vote by mail option and sent it out to service people to essentially what people in Texas would call vote harvest for Lincoln, and that Lincoln won the election, and the rest is history. But the vote by mail without excuse has been something that has been utilized since at least that time period in history, and since the 1860s. But still, it's the case that many states, many large states, require you to have an excuse to vote by mail. So some people get the comfort of home to vote, and other people have to go find a polling location, get through the weather, overcome the transportation, stand in line, navigate the check-in desk, and all of those additional burdens keeps people from going.
Okay,
Well,
and I was just going to say, I think there's just one more quick question from Sue. So if you would do that very quickly, and we will finish up this. Oh, I was wrong. Okay. That's it.
all right,
right.
well, on behalf of all of our attendees and the league in general, the mission of the league that aligns with yours, we want to thank you so much for your time and your expertise and your career as a voting rights advocate. Thank you.
Well, thank you. Thank you for including me.
Thank you
Hopefully
so
this
much.
was interesting for folks.
Thank you.
See you soon.
Bye-bye.
Okay.